Okay, we are on our last set of briefs. This is Chapter 9. And Chapter 9 deals primarily with the rules of evidence. And we talked about um, prosecutors' responsibility, law enforcement's responsibility. So there's four cases. The first one is a little different than the other three. The first one is you have a defendant that's being charged with unauthorized gun sales. And so you have the um, uh, the territory of Puerto Rico, and then you have the federal government. So the defendant handles his case in the federal court, and then that case is completed. And now he is going to the territorial court in Puerto Rico, where he's also been charged with the same crime. So you have question is, has jeopardy attached, which is the other issues that's part of Chapter 9, which is the majority of Chapter 9, actually. And in this case, what he's arguing, what the defendant's arguing, is that, look, I've already been charged once with the crime, I've been convicted, so you can't now, you, the government, can't come back and charge me a second time. The problem is double jeopardy does not protect you from this type of prosecution. The federal government functions independent from the state government. And if you remember from Chapter 1, when we first met, we were still in the classroom before the virus, we could still see each other's face. We talked about the separation of powers. And part of that is we talked about that the federal government is a separate and independent government from each state government. So the state government holds its own power. It's given its own power by the establishment of the state itself. So you can be charged twice. If you commit a crime that's a federal offense and a state offense, you can be charged twice. And so he appeals, saying that double jeopardy is attached when he dealt with it in the federal level. So the territory of Puerto Rico could not come back and charge him a second time for the same transaction and occurrence, the same event. And the court is saying no, double jeopardy does not apply in this case. That's not what our founding fathers had in mind. And because these are two separate governments, you can be charged. And that rule stands today. So if you, for instance, are involved with child pornography and you're sending stuff over state lines and you're sending interstate, the federal government can come after you and the state government can come after you, and you can be charged twice and convicted twice and have to do both sentences, once in federal system and then once in the state system. Okay. Next case, it's an issue of discovery. You had this is unfortunately happens more often than you'd like to admit, and that is what you have is you have officers that investigate a killing, and part of the evidence that they collect is not given to the prosecutor. And then later on, it's discovered that there was other evidence available for the defense. In this case, there was contemporaneous descriptions given by 6 eyewitnesses, the computer printout of license plate numbers of the cars that were in the parking lot. Now, for the prosecutor, this may have been information. Let's assume for the moment that the prosecutor had the information. And the prosecutor would have looked at it and said, okay, well, this information is really doesn't really do me any good. That's not something I'm going to use at trial. The fact that they have information like this, it should have gone to the defense attorney. The question here is, you have law enforcement that's in physical possession of the information, and they never turn it over to the prosecutor. And so the prosecutor does not have the opportunity to turn it over to the defense. And so the defense is arguing that the prosecutor had a duty, an independent duty, to turn over the evidence, and that they are still held responsible for the evidence, even though it was not physically in their custody. And in this case, the court agrees. So the general rule is this: if the evidence is in the possession of the law enforcement agency, the court's going to say, you, the prosecutor, have possession of it, and you have to turn it over. In the real world, this would even mean that if the prosecutor did not know that the evidence even existed, they're still responsible for it. And you could be asking yourself, well, how does this happen? when you have a case like a shooting or a murder, law enforcement in a big agency like Fresno or Clovis, you're going to have the agency send out multiple officers out to the scene initially. You may have 5 different officers, 10 officers collecting evidence, and they are required to document the collection of the evidence. They have a filing system so that all the officers are using the same base number so that any reports generated, any evidence collected falls under this base number, and then so it all goes to the same place. Unfortunately, there are times when officers will write down the wrong number, or they may be given the wrong number by dispatch. And so the bottom line is they've collected evidence, they've talked to witnesses, there are police reports that are generated that don't go to the correct location. And it's only after a search, maybe based on the defendant's name or based on other information, that the law enforcement agency is able to determine where the reports should be filed or where the evidence should be attached to as far as a case number. And unfortunately, that may happen after the trial. It may happen in the middle of the trial. And so the prosecutor oftentimes, not often, but it does happen, where they're blindsided. And the courts have ruled that, that's not their problem. They set a high standard, which they should, and they place the burden on the prosecutor, which they should, and they put the burden on law enforcement, which they should. And keep in mind, because of the abilities that we have today and the technology we have, the opportunity for this mismatch or this misfiling of information should be at a minimum if eliminated altogether. So, although I've been on the ugly side of this argument, and I've been caught in a situation where evidence was available and I had no idea that it even existed. The officer made an honest mistake, and clearly I had no clue. And so it's very frustrating. It can be embarrassing, but it's the right decision by the court. They hold law enforcement to a high standard. Somebody can lose their liberties, and rightfully so. Law enforcement, including the prosecutor, should be held to a high standard. All right. So you got Arizona, I believe Arizona versus Youngblood is the next case. And in this case, this is a mistake that prosecutors make at times, which unfortunately can happen. And they had information that they deemed not to be relevant. So they had semen, but it was inconclusive when they initially did the test. And one of the things about DNA testing, that over the years, the DNA testing has become more and more sophisticated. So initially with DNA testing, it was a certain type of DNA testing. It required large amounts of blood in order to complete the testing. And then over time, the technology has improved. Now you need just a small sample. You can do different types of DNA. You can use the hair roots. The DNA that's stored in your hair roots can be used. Saliva can be used, and so it's becoming more sophisticated. So years ago, when they would collect semen, and they would have said years ago, well, we can't really identify anybody based on this fluids that we have. Today, you can go back and take those same fluids and actually do DNA comparisons. So in this case, the prosecutor made a mistake, and saying that the semen sample had no value, and so they destroyed it. And so the defense rightfully argued that they were entitled to that fluid. They were entitled to at least have the opportunity to test it, and that it was the duty of the prosecutor to preserve the evidence. And the defense in this case is absolutely right, that law enforcement and the DA's office has a duty to preserve the evidence. And so by law, they should have kept that evidence in storage and kept it properly stored to preserve it through the appellate process. All right. And then you've got Koch versus Georgia, which I think is our last case. So the question here is a little different than the other cases. It's about excessive punishment. And you have a defendant that was convicted of rape where the punishment was death. And so the court said no, that the punishment did not fit the crime, is basically what they're saying. They talked about what's acceptable with society. And so in this case, I would look at the court's opinion and how they determine, they look at the history, they go back to 1925, they go back to 1971, and they're looking at the history of crime and they're looking at the history of punishment. And they make a determination that the appropriate punishment for rape is not death. In California, just so you know, if you're convicted of one count of rape, the punishment is 3, 6, or 8 years in prison. Now, we do have 3 strikes, also for your knowledge. If you have 2 or more, if you have a prior conviction on a qualifying sexual assault offense, or if you're being charged with multiple sexual assault offenses, you may be exposed to 25 to life. So, but the death penalty is off the table when it comes to rape. Okay, that was your last case. So I hope you feel good about that if you're doing these cases. And congratulations that you've made it this far. That says a lot about you that you were able to stick it out through the semester, and with the additional challenge of online education, you were able to make it work. So that says a lot about you, and you should be very proud. And I'm proud of all of you for the work you've accomplished this semester with all the challenges that we had. So if you have any questions, email me. Get your briefs in as soon as possible. That's the biggest part of your grade. And then email me if you have any issues or problems. And try to get everything in before the deadline. I've opened up the Chapter 9 quiz is on the week of our finals so that we have some type of final during finals week. All right, take care, be safe, and I hope you have a fabulous summer. Hope it's far better than this semester was as far as being locked up in home. So take care, and I've enjoyed being with all of you. And I was enjoying being in the classroom with you until we got separated. So, all right, everyone, take care.